Good day everyone, we are the reporters of Article 1172 and I, John Albert L. Sevilla, will start the discussion. Article 1172. Responsibility arising from negligence in the performance of every kind of obligation is also demandable, but such liability may be regulated by the courts according to the circumstances. So Article 1172 talks about negligence or kapabayaan. So when negligence is present in the process of performing an obligation, any damages done to the thing is demandable by the creditor. However, depending on the circumstance or circumstances, the court may be able to mitigate the liability of the people involved in the negligence in case there is a valid waiver. An example of negligence is when a driver runs a stop sign causing an injury crash, or when a store owner fails to put up a caution wet floor sign after mopping up the floor. So, how is negligence different from fraud? In fraud or dolo, there is deliberate intention to cause damage or prejudice. It means that the process and the results are planned carefully by the doer. Whereas in negligence or culpa, although voluntary, that is not done through force, still there is no deliberate intention to cause damage. In other words, negligence is just the act of doing something without thinking of the consequences. Since fraud is intentional, any liability done or arising from it cannot be mitigated or reduced by the courts because fraud is a criminal act and is against public policy. However, liability arising from negligence may be reduced in certain cases. Example, a customer slipped because a store owner failed to put up a caution wet floor sign after mopping up the floor. If a customer is hospitalized, the store owner can just pay for the hospital bill and anything else the customer needs to recover completely instead of going to jail. Additionally, waiver of an action to enforce liability due to future fraud is void. So this is understandable since no one wants to be cheated on. However, waiver of an action to enforce liability due to future negligence may in certain sense be allowed. This will be explained further later. Moving on to stipulations regarding future negligence. Gross negligence can never be excused in advance, for this would be contrary to public policy. So what is gross negligence, by the way? Gross negligence is a lack of care that demonstrates reckless disregard for the safety of lives or for the safety of lives of others. This violates people's rights to safety. So the keywords there are violate people's rights to safety. Example, you are a nanny of a 5-year-old baby. Part of your obligation and stipulation is to take good care of him every day. Of course, every child is curious, especially those who can walk. One day, nag-concert live on Facebook ang imuhang mga Korean idol. Then you are so busy watching the live concert, you forgot to watch over the child. Wala na ka nakabantay nga nigawas na day ang bata sa balay o nakidnap. Siyempre, bisag unsaon nimo og plea sa korte nga nalingaw kag tanaw and dili nimo intention, mapriso jud ka tungod kay na-violate ang maong karapatan sa bata to safety. Another example, you are obligated to deliver an item sa imuhang boss at around 3 p.m. Unya pagka alas 2 sa hapon nagdula pa kag ML. Ug human nimong dula, ana pa ka nakabantay sa oras. Sa pagdali-dali nimo, nagpakusog kag padagan bisag kabalo ka nga traffic and against public policy na siya. Sa unahan, nakabangga ka og sakyanan and na hospital na hinuon ka ug ang driver sa sakyanan imong nabanggaan. So that is gross negligence. So moving on to simple negligence. Simple negligence may in certain cases be excused or mitigated. It is also referred to as ordinary negligence. This happens in situations where someone doesn't take precautions. So example of simple negligence is katong example kagaina. Nagmap ka sa salog tapos wala ka nagbutang og caution, wet floor nga sign unya na slide imong customer. So, 3 kinds of usual stipulations in a bill of lading. Bill of lading, it is the contract for the shipping or transporting of goods. The first one exempts the carrier from all liabilities for loss or damage occasioned by its own negligence. This is against public policy and is void. Of course, nagpalit ka og laptop na bayaran na nimo, so it is the obligation of the carrier to deliver the laptop. Samtang nag-deliver siya, nihunong siya para mangapi. Pero nakalimtan niya og secure ang iyahang ipang-deliver. Pag human niyang pangapi, nawala ang mga i-delivery niya kay nakawat na. So according to the first stipulation of the bill of lading, dili exempted ang carrier sa maong loss. Ug according to Article 1745, any of the following or similar stipulations shall be considered unreasonable, unjust, and contrary to public policy. So, sa kaning article, daghan og stipulation pero duhara ang mo relate sa negligence. Ug mao ni sila. That the common carrier will not be liable for any loss, destruction, or deterioration of the goods. So, of course, every customer should get what they paid for. So, kung nawala, tungod sa negligence, kinahanglan gid sila mobayad. Anaa gid sila liability. So, the next stipulation is that the common carrier need not observe any diligence in the custody of goods. So, according to Article 1163, every person obliged to give something is also obliged to take care of it with the proper diligence of a good father of a family, unless the law or the stipulation of the parties requires another standard of care. So, if walay diligence nga gibuhat ang nag-deliver or ang carrier, so iyang gi-violate ang Article 1163 of the Civil Code of the Philippines, making him or her liable for any damages sa butang nga iyahang nawala. The second one limits the liability to an agreed valuation, no matter how much damage is caused. In other words, no matter how much damage is caused, the value that can be recovered is the same. This is also void since a wealthy company would be able to afford being negligent. Again, this is against public policy and it is so unfair po para sa mga creditor na dili nila ma-recover ang damages na ilahang gibayaran gikan sa shipper na nawala pag ship na katong nasa custody sa carrier. So the third one limits the liability to an agreed value unless the shipper declares a higher value and pays a higher rate of freight. This is valid and enforceable as a rule. Example of this is the case of Frexas Company versus Pacific Mail Steamship Company. Frexas, the plaintiff, ordered something, then Pacific Mail Steamship Company was obligated to deliver the thing. The course was from San Francisco, California to Manila, Philippines. So when the steamship Colosa arrived in the port of Manila, the delivery was not made. So nilarga ang steamship Colosa without landing the plaintiff's merchandise. The shipper declares that the value of each package described on the face of this bill of lading does not exceed the sum of $100, unless the shipper shall expressly declare, and there shall be written on the face thereof a different value, and upon such basis of valuation of said packages, the rate of freight thereon is adjusted. The invoice of the said one case of hat bands at the time of delivery to the steamship Colosa was the sum of 1,624.78 pesos. This amount was claimed by the plaintiff from the defendant as damages for failure to deliver the said merchandise. But the defendant tendered to the plaintiff only the sum of $100 US currency in payment of plaintiff's claim, which tender plaintiff rejected, whereupon the present action was instituted. So ni-offer si defendant of $100 to compensate for the loss of the thing and for the fulfillment of the obligation. Pero wala gidawat ni plaintiff on the grounds that there is negligence on the part sa defendant since wala may merchandise na pakita atong pagland sa barko sa Manila port. So the issue is whether or not the common carrier, by stipulations inserted in the bill of lading, limit its liability for the loss or damage to the cargo to an agreed valuation of the latter. Ilimit ba ni carrier, which is the defendant, ang iyahang liability sa stipulation sa bill of lading, $100 raman ang agreed value. Ang ruling ani is that since it was in the face of the bill of lading that the value of each package does not exceed $100, therefore the defendant may limit its liability to the plaintiff. Ang ending, $100 ra gyud ang nabayaran ni defendant ngadto kay plaintiff, kay mura man ang naa sa bill of lading. So based on this case, the third stipulation is valid since mao man jud ang ilahang prior agreement before giship ang maong merchandise. Another example for this stipulation is the case of Ismael and Company versus Barreto. In this case, the plaintiff is Ismael and the defendant is Barreto. Ang naitabo ni nga kaso is si Barreto is to deliver the consigned goods by the plaintiff to the consignor, which is si Salomon Sharoff. So gusto i-recover ni plaintiff ang damages gikan kay defendant since all four cases of merchandise was never delivered to Salomon, assuming there is negligence involved because ang upat ka merchandise wala man nakita or wala man na-deliver kay consignee and was never returned to the consignor. So diba, when consigning goods, i-deliver ni consignor ang goods kay consignee and ipangbalik ni consignee ang mga goods nga wala na baligya ngadto kay consignor. Since there was no return, nag-assume si plaintiff nga na-receive na ni Salomon ang goods not knowing nga wala di ay na-receive. So after almost 6 months, gi-brought up ni plaintiff ang kaso sa lower court laban kay defendant para i-recover ang damages. However, the plaintiff's right of action was barred because the stipulation only allows up to 60 days from the time of action or from the time of cause of action accrued. So, the issue is whether or not the plaintiff's right of action is barred and whether or not the defendant should limit their liability. The ruling is that the defendant should limit his liability since it was stated in the bill of lading that each case should not exceed $300. Moreover, the issue was brought up after almost 6 months, considering that the bill of lading only allows up to 60 days from the time of cause of action accrued. So na-late kaayo si plaintiff pagreklamo og $300 sa gyud ang nabayran ni defendant kay mauman ang naa sa bill of lading and the shipper did not declare a higher value. Therefore, the liability of the defendant is limited. So that is all for my discussion, and the next reporter will proceed.
So good day everyone, I am Jubel Rose Wadilianes and I will be the second reporter of the Article 1172. And today we will discuss about the Phonics Assurance Company versus Macondray and Company Incorporated. So this case, we will relate it to the third of the three kinds of the stipulation in the bill of lading, which is the limits of the liability to the agreed value unless the shipper declares a higher value and pays a higher rate. Okay, so let's go to the facts of the case. So, unsa nahitabo sa case? So, ang nahitabo sa case, a shipper in South Carolina, nagpa-ship siya dito akong SS Fernbank na para i-deliver dito akong Floro spinning wheels in Manila, which contain of a textile machinery spare parts, and it was a 1 box and 1 carton of gipaship 1 box of 1 carton with a value worth of $4,183.74. However, the shipper did not declare the value in the bill of lading, and only nagbayad lang siya for $46.20, which is the usual freightage only. Okay. Onya, dito sa bill of lading, gibutang dito nga stipulation to the effect that in the case of loss or damage, the carrier's liability was fixed only at $500 unless a higher value is declared in the bill of lading and extra freightage paid if required. This time, the freightage would be on the value of ad valorem basis. Okay. So, klaro kayo dito agibutang sa bill of lading na if naay damages or loss sa ilang mga need ipa-ship, ang fix na ilang liable lang is $500. Unless gibutang jud dito sa bill of lading ang value sa mga products o nagpay og extra freightage if required siya. Okay. The shipment was insured by $5,450 with Phoenix Insurance Company. So insured na ito katong shipment kang Phoenix Insurance Company of New York. Pag-abot diri sa Pilipinas or sa Manila, na-discover nila na a portion of a shipment had been damaged to the extent of $1,512.78. And the Floro spinning mills sued both the carrier and the insurance. So the Phoenix Insurance Company paid the equivalent $1,512.78. So ilang gibayaran ang katong shipper. So gibayaran sa Phoenix Insurance Company ang katong shipper for the worth of $1,512.78, which is the actual value of the goods damaged. In turn, the insurance company asked reimbursement from the carrier. The carrier, however, said that it was willing to answer for only $500 as stated in the bill of lading. So, nangayo og reimbursement si Phoenix Insurance Company dito sa carrier. Og si carrier niana sila, oo, muhatag ko, pero only for $500 kay more tong stated dito as a bill of lading. So, what is the issue? Ang issue is how much reimbursement must be given? $500 or $1,512.78? Okay. The answer is the reimbursement should be only $500. In view of the stipulation in the bill of lading, a stipulation sanctioned by a jurisprudence. So, dito gibutang dito sa bill of lading na only $500 if na ay damage or loss sa shipment, liable lang sila for only $500. And remember, the shipper, it is noted that no value higher than $500 had been declared. So, the shipper wala gi-declare sa bill of lading ang unsa jud ang value sa shipment and only paid for the usual freightage cost. So, the carrier company is only liable for $500 and not for $1,512.78. Okay. Next, we will discuss the rules of contracts of adhesion. So before we will proceed to discuss the rules of contracts of adhesion, we must discuss first, or we must know what is the contract of adhesion. Unsa man ang contract of adhesion? Magtako na ta sa rules, pero what data kabalo sa contract of usa nang contract of adhesion, di ba? So kinahanglan ato sang ilhon sa nato ang contract of adhesion. So unsa man ang contract of adhesion? Okay, contract of adhesion is a legal agreement that is drafted by one party but not the other. Means that the party signing the agreement had no chance to bargain for the agreement's terms. Instead, it is a take it or leave it situation. So meaning, mas advantageous ang isa ka party and ang isa ka party dili. So not equal sila. So tabingi ang nahitabo. Okay. So now, mo na ang contract of adhesion, unequal of portions or positions between the two parties that forms a contract. Okay. So now let's talk about the rules of the contract of adhesion. What is the rules of contract adhesion? There is a greater freedom to stipulate on negligence if the parties are on an equal plane. Okay ra kayo na freedom of stipulation of negligence if dali ra kayo siya if ang parties is on an equal plane. Not where there are obviously in an equal position. So which is an equal position, which is the contract of adhesion, such as in the case of employment or transportation contracts. Moreover, stipulation on a negligence must be strictly construed against the party situated in a higher and more advantageous position. So, unsa may pasabot sa strictly construed na giingon, di ba? Okay. Strictly construed means that a court must make a decision based on the language used in writing as statute and must know interpretation of a law. So meaning mag-desisyon ang korte based dito sa contract sa parties and not o dili nila i-appeal ang mga about sa law. So, magdesisyon sila kung usabi angay buhaton nila para dili siya maging tabingi ang nahitabo dito sa contract. Para ma-equal sila tanan. So, mao na ang pasabot sa strictly construed. Bali na anay engagement ang korte ana. Okay. So, para mas masabtan na to, unsay pasabot sa rules of contracts of adhesion, let us discuss unsay nahitabo sa case kang Delgado Brothers Incorporated versus Court of Appeals et al. So unsa may nahitabo? So ang nahitabo sa case is si Richard Klepper shipped through the American President Lines a leaf van containing certain personal household effects. While the van was being unloaded by the gantry crane operated by Delgado Brothers, it fell on the pier and breaking the goods inside. So si Richard Klepper, naa siya'y shipment na iyang gipaship dito sa American President Lines. Nya pag unload ato na shipment ni Richard Klepper gamit sa gantry crane na tag-iya sa Delgado Brothers, nahagbong og nabuak siya. So pagkabuak, syempre nangayo og compensation ang si Richard Klepper sa goods na damage. Si Si Delgado Brothers Incorporated, sila tong official unloaders of the cargoes shipped on the American President Lines Ltd. So, sila ang official unloaders of the cargo. So, kung naay cargos na moabutay, sila ang naga-unload ana. So, mo na ilang trabaho. Mo na ilang kontrata between kang American President Lines o kang Delgado Brothers. So, di sa contract, gibutang dito ang gibutang dito sa contract na we, the American President Lines, hereby assume full responsibility and liability for damages of cargoes, ship or otherwise arising from the use of the unloading crane of the Delgado Brothers Incorporated, and we will not hold said company liable for responsible in any way thereof. So the shipping company was ordered to pay for the damages. Okay. So meaning mo to ang ilang kontrata between sa ila duha. So giingon jud dito akong tanan ana si American President Lines na if naay damages between sa cargos na gipang ship na nag-arise sa paggamit atong gantry crane natag-iya ni Delgado Brothers, tanan na damages will be hold by the American President Lines and not on the Delgado Brothers Incorporated. So what is the issue? Unsay may issue, unsay problema. So the issue is the Delgado Brothers Incorporated required to reimburse the carrier? Required ba sila mag-reimburse? The answer is no. Because the exemption in the contract from liability on the part of the Delgado Brothers Incorporated, the exception is clear. So, klaro kaayo dito na gibutang jud dito sa kontrata na dili liable ang Delgado Brothers sa mga damages sa paggamit if nagamit sila sa gantry crane na tag-iya sa Delgado Brothers. So, Delgado Brothers is not liable.
Hi everyone, I'm the next reporter. My name is Christine Bacarizas and I'll be talking about comments 4 and 5 in the article 1172. First is the comment 4, kinds of culpa classified according to the source of the obligation. So, culpa refers to negligence, fault, or blame. It is used to describe situations where someone's carelessness or failure to act responsibly leads to harm or damage to another person or property, meaning kapabayaan. So, for point A refers to culpa contractual, or also called as contractual negligence, or that which results in a breach of a contract. So, kini siya nga negligence results here obviously sa breach of contract. It means that one party failed to fulfill their contractual obligations due to their negligence. For example, a delivery company has a contract to deliver fragile items. If they handle the items carelessly and break them, they are negligent in fulfilling their contractual obligations. Next point is for culpa achilliana, point B, also called as civil negligence or tort or quasi-delict. It refers to negligence that is direct, substantive, and independent of the contract. For example, you drive a car, tapos you accidentally hit a pedestrian while driving, and that is the case of culpa achilliana. For the third point, point C, culpa criminal, or also called as criminal negligence, or that which results in the commission of a crime or a delict. So this is a criminal negligence which results in the commission of a crime or a delict. For example, if a person drives carelessly or recklessly and causes an accident that injures or kills someone, they may be charged with criminal negligence. So for example daw, na-drive ka og sakyanan tapos napataka lang ka, wala ka nag-follow sa rules, tapos naka-aksidente ka og tao or much worse, nakapatay, then you may be charged with criminal negligence. So now I'm done with comment number 4. I'll proceed to comment 5. Distinctions. The three kinds of culpa. Culpa contractual, culpa quiliana, and culpa criminal. So first, I'll be talking about point A each of culpa contractual, culpa criminal, culpa contractual, culpa quiliana, then culpa criminal. Then proceed to point B of culpa contractual, culpa quiliana, and culpa criminal. So on and so forth. So first is point A. For culpa contractual, it states negligence is merely incidental to the performance of an obligation already existing because of the contract. So it is a negligence that occurs while fulfilling an existing contract. For example, na kay app like Grab or Uber, kanang makapabook ka og sakyanan, pwede nag-book ka o taxi kay lagi nagdali ka kay hapit na mag-start ang meeting kibali nimo sa company nga yung gitrabahoan kibali. So nag-book ka atong Grab or Uber na mo pick up sa imo within the specified time. Tapos ang driver sa katong taxi or ang driver sa Grab or Uber fails to pick you up, the passenger, ikaw ang passenger, at the agreed time. In this case, it causes you to miss a meeting. The context for this example is that the negligence, which is the late arrival of the driver, is incidental, meaning related to the performance of the existing contract between the taxi driver and the passenger. Next is for point A. Point A of culpa quiliana is negligence here is direct, substantive, and independent, which means that negligence is direct and independent of any contract. For example, ikaw, dog owner, tapos failed ka to secure your dog away from people. Kanang wala nimo nakulong kay nagpasagad kibalik ka. Tapos sa kanay mong pagkapasagad, pagka negligent nimo, naka-cause na noon ng iro na makapaak o mga tao, passerby. So the context for this example is that the negligence of not securing the dog is direct, substantive, and independent. Next is point A of culpa criminal. So for culpa criminal, negligence here is direct, substantive, and independent of a contract. So similar lang siya sa culpa quiliana. For example, for this is a driver under the influence, meaning hubog of alcohol, causes an accident resulting in injuries to another person. Excuse me. So the context for this example is that the driver's negligence, which is driving under influence, is direct, substantive, and independent of any contract. Now let's proceed to the point B. First is for culpa contractual. Point B, it states there is a pre-existing obligation, a contract, either expressed or implied. So there is a pre-existing contract between the parties. So for example, a homeowner hires a contractor to renovate their home. So ang context aning example is that na pre-existing obligation. Pre-existing obligation ani here is the obligation to renovate. The renovation contract between the homeowner and the contractor. Next is point B for culpa quiliana. It states no pre-existing obligation except, of course, the duty to be careful in all human actuations. So there is no pre-existing obligation between the parties. So example for this is a person accidentally starts a fire that damages a neighbor's property. So the context for this example is that no, there is no pre-existing obligation between the person and the neighbor, only the general duty to be careful. Okay, so next point B for culpa quiliana, culpa criminal. Next point for point B, culpa criminal. No pre-existing obligations except the duty to never harm others. So still similar siya sa culpa quiliana, there is no pre-existing obligation between the parties. For example, a person has a general duty to not harm others, which is not derived from a specific context. So, wala siya specific context, pero dapat lang ka dili mag-harm og others. So, for this example, there is no pre-existing obligation between the person and others, only the general duty to not harm the others or everyone. Tapos next point is point C. First is for culpa contractual. It states that proof needed, preponderance of evidence. So the standard proof is the weight of the evidence. For example, a customer sues a moving company for damaging their furniture during the move. Kanang moving company mo na sila ang mubalin kag balay, mo na sila ang tig-move. Kana sila ni magbitbit sa inyong mga gamit from your old house to your new house kibali. Sila no magbitbit, di ka maghasol-hasol pa. Pero sa kining example, customers use a moving company for damaging the furniture. So while ga-move ang katong moving company na damage kibali ang imong furniture. So the context for this example is that the customer needs to prove that the moving company's negligence by a preponderance of evidence, maybe a picture, video, or any other form of evidence. Ano siya, standard of proof. Next is for culpa quiliana, point C. It states that proof needed, preponderance of evidence. So, similar na siya sa culpa contractual. Standard of proof is the weight of the evidence. For example, a pedestrian sues a driver for hitting them while crossing the street. The context is that a pedestrian needs to prove that the driver's negligence by a preponderance of evidence. Next point. Next is culpa criminal, still the same point. Point C. It states that proof needed in a crime, proof of guilt beyond unreasonable doubt. So, the standard of proof is guilt beyond a unreasonable doubt. So, for example, a person is charged with vehicular manslaughter. Yung vehicular manslaughter, muna siyang pagpatay sa killing a human being due to illegal driving of an automobile, sakyanan, causing a fatal accident. So, nakapatay ka, naka-aksidente ka. Illegal driving pagit ka sa automobile. So, the context for this is the prosecution must prove the person's guilt beyond unreasonable doubt. So, next is point D for culpa contractual. It states good father of family in the selection and supervision of employee is not a proper, complete defense in culpa contractual. Okay? Though this may mitigate damages. Here we follow the rule of respondent, superior or command responsibility, or the master and servant rule. So, ang the good father of the family, dili siya, kana siya nga defense is not a complete defense. For example, an employee of a delivery company steals a package. The context for this example is that the employer in delivery company might be held liable for the employee's actions if they failed to properly select or supervise the employee. So, wala nila natarong o supervise. Muna nakakawat sala gyapon sa delivery company. Next is culpa quiliana. Point D. It states that defense of good father, etc. is a proper and complete defense insofar as employees or guardians are concerned in culpa kiliana. So, ang good father of a family defense is a proper and complete defense. There is a culpa kiliana, which is opposite to culpa contractual. For example, an employer may not be held liable for an employee's off-duty car accident if they exercise due diligence in hiring and supervising the employee. So, ang context kibalian is, ang defense of being a good father of a family in selecting and supervising employees is a proper defense in culpa kiliana. Next is point D, again, still sa culpa criminal. It states that this is not a proper defense in culpa criminal. Here, the employee's guilt is automatically the employer's civil guilt if the former is insolvent, meaning unable to pay debts owed. So, like in culpa contractual, good father of a family defense is not a proper defense. For example, an employee commits a robbery while on the job and the employer is held liable for the damages. So, the context for this example is that the employer cannot use the good father of a family defense in culpa criminal because their employee's guilt automatically makes them civilly liable if the employee is unable to pay the debts owed or insolvent. Okay. Lastly is point E for culpa contractual. It states, as long as it is proved that there was a contract and that it was not carried out, it is presumed that the debtor is at fault, and it is his duty to prove that there was no negligence in carrying out the terms of the contract. So, if a breach of contract is proven, there is a culpa contractual point E, then there was no if a breach of contract is proven, then the debtor must prove that there was no negligence in fulfilling the contract. So, for example, a catering company fails to provide food at the wedding reception was agreed in their contract. So, the catering company is presumed to be at fault for not fulfilling the contract, and it's their responsibility to prove that they were not negligent. Next is for culpa kiliana, point E. It states, ordinarily, the victim has to prove the negligence of the defendant. This is because his action is based on alleged negligence on the part of the defendant. So, the victim has to prove the defendant's negligence. For example, a child accidentally breaks a neighbor's window while playing. So, for the context of this example is that ang katudang parents a child, the child's parent would generally be responsible for proving that they were not negligent in supervising their child. So, dapat responsibilidad sa ginikanan nga i-prove yung self nga dili siya negligent sa pag-supervise, sa pag-atiman sa bata, sa ilang child. Okay? So, next is point E for culpa criminal. It states, accused is presumed innocent until the contrary is proved. So, prosecution has the burden of proving the negligence of the accused. So, the accused is presumed innocent. So, kung nakay-akusahan, tapos wala pa kay ma-prove nga kana siya is dili siya innocent. So, for the meantime, nga wala pa siya na-prove nga dili siya innocent sa lang siya. Like, yung siya akusahan, so presume siya as innocent, and the prosecution must prove their negligence. So, dapat i-prove pa nimo siya nga negligence siya. Ay mawala ang siya dili ma-presume as negligence. Siya dili ma-presume as innocent. Okay. For example, a person is accused of negligent homicide after causing a fatal accident. So the context for this example is that the accused is presumed innocent until proven guilty. So dili sa siya maingon guilty na kadaan. Presumed sa siya nga innocent. And the prosecution has the burden of proving their negligence. So dapat i-prove sa prosecutor sa prosecute nga naagid sila commit na negligence.
Examples of culpa contractual situation. A passenger in a taxi was hurt because of driver's negligence. So this is an example of culpa contractual because there is a breach or negligence in performing the contract. So general rule, the debtor will be liable for the damages according to Article 1170. Even though we can see the formation of contract, as long you are on board to a carriers, paid or unpaid, and there is a breach of contract, so we can say that this is culpa contractual. The driver or owner should act as a good father according to Article 1163 and Article 1173 if both stipulation is silent. And the obligee in this situation will be the passenger, and the obligor is the owner of the taxi and not the driver. This is called respondent of superior or master-servant rule, where fault of a servant is liability of the owner. But if negligent lang jud sa part ni driver, the liability of the owner to pay damages will mitigated or mugamay siya ang expenses according to Article 1173. So, driver's negligence. Number 1, unjustified rate of speed, katong mga driver na magpakusog udagan na bawal sa batas. Then number 2, flagrant violation of courtesies, katong mga drivers na moagi sa mga schools na di maghinay. Number 3, wrong way, katong mga one ways na dapat dito ra siya moagi and then ang driver ni wrong way siya good. And number 4 is driving under the influence of alcohol, so masabot na gina siya. Then number 5 is overtake. So mostly accident is because of overtake. So mga mali na nag-overtake. So on the part of owner's negligence, number 1, failure to repair. So dapat dili na siya unforeseen sa owner na kanang wala siya kabalo na aday i-repair. Dapat kung ikaw owner kabalo na ka na in condition ang thing to make a service. So number 2, hiring incompetent drivers. So this is owner's responsibility na mohar og competent o kanang skilled drivers. Number 3, purchasing defect from manufacturer. So same as number 1, dapat dili niya siya unforeseen circumstances. Dapat nakabalo na ang driver and then kabalo siya mamili og unsa gitarong nating gamit or things. So owner can't defend claim of force majeure. So katong dili niya ma-defend sa court na wala siya kitaan na circumstances, kay dapat responsible na niya na kana na side every corner kabalo siya sa mahitabo. Example of true event situation of a culpa contractual. The case of Antonio V. Roque versus Bienvenido P. Buwan. So facts, in a bus bound for Pampanga, a passenger Antonio V. Roque was injured as a result of driver's violent swerving. So suddenly change of direction. So kalitro siya gliko without signaling, causing head-on collision with another vehicle. So issue, is the bus driver liable for negligence? So for me, based on my understanding, si bus jud is naagi siya liable to pay damages to Antonio V. Roque because there is a breach of contract where si Antonio wala siya kaabot sa iyang destination and then di siya safely, so there is a body damage na bayan ni bus company. And then if i-rolling na siya sa korte, and then si defendant si bus mag-prove siya na nag-perform siya og due care or extra due care sa pag-driving or pag-perform sa contract. So there is a chance na maless or makuhaan ang iyang expenses to pay damages, or pwede pod mawala na gid ang liabilities, o so there is an extinguishment. Number 2, of a true event situation. The case of San Pedro Bus Line versus Navarro. Facts. A passenger on track was hurt, but in a criminal case against the driver, said driver was acquitted. So Navarro charged criminal case against the driver, but the driver got acquitted or not guilty or napawalang sala because it is not a criminal case, rather it is a culpa contractual. So si Navarro ni proceed siya og charge kang bus owner. So according to Article 172 na si owner gid ang liable pag iyang servant is nagkamali biskan pag nag-perform siya og due care. So pag ma-ruling na po niya siya sa korte, same as case number 1, and then kung ma-prove po ni bus owner na both sila driver ug owner nag-perform og due care or extra diligence, so the court will kanang mapawalang sala sila, so dili sila liable for damages or kaya there is a chance na ma-less ang kanang expenses to pay damages. And then if madaog pud si Navarro, makuha na niya iyang benefits, ay not dili siya benefits, or makuha niya iyang karapat dapat na madawat niya na amount of money where kanang ma-equal niya ang iyang ang na-damage niya na dawat og iyang expense na nagasto.
Hi, I'm Raymond Christopher Gunayan and I am the fifth reporter of the Article 1172. 6 instances of recklessness on the part of the driver. These are the instances that may causes accident. First one is driving at an unjustified rate of speed, flagrant violations of the elementary courtesies of the road, failure to signal properly, deliberate entry on one-way streets, or his intoxication at the time of the mishap as distinguished from the mere drinking of hard liquor. In general, an attempt to pass another vehicle which fails to give way. 7. Instances of recklessness on the part of the owner or operator himself. Owner or operator fails to repair defective parts in the vehicle or allowing a worn-out condition or damage of the vehicle that runs through along the highway, or the failure of the carrier to provide any cover at the right of the side of the bus to safeguard passengers sitting thereat from falling therefrom. Failure of the passenger to hold onto the arm of the seat instead of the hand of a friend mitigates, however, the liability. So passengers needs to hold onto the arm of the seat, for it is a reasonable effort to limit the harm they suffer from the recklessness of the operator. Owner fails to furnish a competent and tested driver to whom the owner or operator must issue, when essential, proper instruction for safe maneuvering on the highway. So the owner needs to find a reliable one to operate his or her unit. Owner fails to detect a defect in an appliances purchased from a manufacturer, a defect that could have been discovered by the carrier. Case Lourdes Monsayak versus Benedicta de Lara, Liberation 21151, June 26, 1968. A driver of a jeepney was found recklessly negligent, thereby causing injuries to his passenger. Issue: whether the owner or operator of the jeepney liable for exemplary damages in addition to other kinds of damages. Held: not necessarily. A principal or master can be held liable for exemplary or punitive damages based upon the wrongful act of his agent or servant only when he participated in the doing of such wrongful act or has previously authorized or subsequently ratified it with full knowledge of the facts. Exemplary damages punish the intent, and this cannot be presumed on the part of the employer merely because of the wanton, oppressive, or malicious intent on the part of the agent. So, exemplary damages will only punish the intent if the defendant's willful acts were malicious, violent, oppressive, fraudulent, wanton, or grossly reckless. Case Ambaan et al. Versus Villosilio et al. Court of Appeals, General Register Number 56874R, July 8, 1981. Fact: there was a public utility jeep driven by a reckless driver, as a result of which passengers suffered injuries. Issue: whether or not the passenger can sue the owner-operator of the vehicle. Ruling: yes, the passenger can sue the owner-operator of the vehicle. The injured passengers of a public utility jeep driven by a reckless driver can sue the owner-operators of the jeep without the necessity of first bringing criminal case against said driver. The governing law in such a case is the Civil Code, which requires common carriers to carry their passengers safely to their destinations with the exercise of extraordinary diligence. Considering the negligence of the driver, it is clear that under the master and servant rule, the liability of the owner's operators is not subsidiary but direct and immediate. The master and servant rule is also known as the doctrine of resplendent superior. Under this rule, the master, to escape liability, cannot put up the defense of a good father in the selection and supervision of employees, except to mitigate said liability if this defense is duly proved. So, the resplendent superior, meaning that an employer is responsible for the negligent acts or omissions of its employees. Note that negligence is a question depending upon the facts of each particular case. Indeed, it is a question of facts.
I am Princess Grace A. Bayuna, your sixth reporter for the Article 1172.
What is culpa aquiliana, or civil negligence or tort or quasi-delict? According by the book of De Leon, culpa aquiliana is negligence which by itself is the source of an obligation between the parties not formally bound before by any pre-existing contract. It is when a person is guilty in culpa aquiliana, he or she is guilty of an act or a failure to act. This act causes damages to somebody else without any type of contractual relationship between the defendant and the victim. When a person causes such damages, he or she must compensate the victim for them. Example: a pedestrian was hit by a taxi and suffered physical injuries. The taxi driver was negligent and was responsible for the injury. It is a culpa aquiliana since there is no pre-existing contractual relationship between the pedestrian and the taxi driver and the owner of the taxi cab company. So the injured pedestrian can bring an action based on culpa aquiliana, tort or quasi-delict against the two or both the taxi driver and the owner of the taxi cab company. It's because the driver is responsible for his negligence in making possible for the injury. Therefore, in this case of culpa aquiliana, if the owner can prove due diligence in the selection and supervision of his driver, he could not have been responsible in any way for the injury. Thus, this defense is appropriate or proper for the employer, and if proven, he will exempt him from liability or responsibility. Since
it is the pedestrian who alleges negligence on the part of the defendant, it is his or the pedestrian's duty to present and prove said negligence. In other words, he will have the burden of proof. As stated by the Supreme Court, as a general rule, it is logical that in case of culpa aciliana, a suing creditor should assume the burden of proving the existence of the negligence as the only fact upon which his action is based. So, here are some cases about culpa aciliana. First, the Ibanez et al. Versus North Negros Sugar Company Incorporated et al. L6790, March 28, 1955. Facts: Pedro Ibanez and Rosario Ibanez are the brother and sister and immediate heirs of Cesar Ibanez, who was one of the two persons who died as a result of the collision between the car and the train, wherein it is said that in the car is Cesar Ibanez was riding and being driven by Jill Dominguez, and the train was owned by the North Negros Sugar Company Incorporated. A civil action based on culpa aciliana was instituted by Pedro Ibanez and Rosario Ibanez against Primitivo Gustillo Loreto Perez and their employer, North Negros Sugar Company Incorporated, seeking to recover damages for the death of their brother, Cesar Ibanez. The Court of First Instance dismissed the case. The Court of Appeals reversed the judgment of the lower court and held the North Negros Company Incorporated liable for the death of Cesar Ibanez, ordering it to pay plaintiff appellant Pedro Ibanez damages. Issue: Is the Court of Appeals correct in awarding moral damages to Ibanez? Ruling: No, the brother or sister of a deceased cannot claim moral damages. Because it may well be said that culpa aciliana or quasi-delict is punished both by the old civil code, the previous legislation, and by the new civil code, but a less severe sanction or penalty for culpa aciliana is provided for in the new civil code. It follows, therefore, that Article 2206 of the new civil code, which provides that only the spouse, legitimate and illegitimate descendants and ascendants may demand moral damages for mental anguish by reason of the death of the deceased caused by quasi-delict, should be applied in the case at bar. Hence, petitioner herein, who claims moral damages for the death of his brother Cesar Ibanez caused by quasi-delict, is not entitled to and should not have been awarded moral damages by the Court of Appeals. Case Digest number 2, Ramos vs. Pepsi Cola, L22533, February 9, 1967. Facts: A driver of Pepsi Cola is admittedly negligent in a vehicular collision, so suit was brought by the other car owner, which is Ramos, against both the driver and the Pepsi Cola. But Pepsi Cola was able to prove diligence in selection or no culpa in eligiendo, no fault selecting or poorly made decision, and supervision, no culpa in vigilando or no fault of supervising of the driver. Issue: Is Pepsi Cola still liable? Ruling: No, otherwise it would have been liable solidarily with the driver. Since in Philippine torts, we do not follow the doctrine of respondeat superior, which means let the master answer, or which is a legal doctrine that an employer is responsible for the actions of employees performed during the course of their employment, or where the negligence of the servant is the negligence of the master. But instead, in Philippines, we follow the rule of bonus familias, or the good father of a family. So the negligence of the employer here is only presumptive or presumptuous it can therefore be rebutted as in this case.
Okay, so another case example of civil negligence is Villanueva versus Court of Appeals. So anyway, I am Ria Intakan and I will be presenting the remaining some illustrative cases of civil negligence and the criminal negligence. So, in Villanueva versus Court of Appeals case, there are 7 persons were killed, 13 others were injured on February 16, 1958. Because of the accident that was due to the concurrent negligence of the drivers of the 2 buses, it appears that another passenger bus owned by Patricio Hufana and driven by Gregorio Hufana tried to overtake the passenger bus driven by Hermenegildo Aquino, owned by Villanueva, the petitioner. But instead of giving way, Aquino increased the speed of his bus and raced with the overtaking bus. Aquino lost control of his bus as a result of which it hit a post, crashed against a tree, and then burst into flames. So the issue is, who will be held liable? So, according to the court, 4 persons are liable: the owner of the bus, the driver of the bus, the owner of the other vehicle, and the driver of said other vehicle. So, under liability is solidary. Solidary means it's an obligation under which any of 2 or more obligors can be held liable for the entire performance, like payment of a debt. So, notwithstanding the fact that the liability of the bus company is predicated on a contract, while the liability of the owner and driver of the other vehicle is based on a quasi-elect. So therefore, the decision appeal term is hereby modified in the sense that petitioner as well as respondents Patricio Hufana and Gregorio Hufana are jointly and severally liable for the damages awarded by the trial court. Okay. Next case is People versus Alejandro Oltan Jr. So, if a driver on one side of the street desires to cross the same to be on the other side, it is not sufficient for him to put on the left side light of the vehicle. It is of judicial notice that many drivers in our country today pay little heed to such a signal, particularly if the vehicle being driven by approaching driver is speeding. So so based on my observation dyan, isa sa mga reasons kanong na-ay traffic or na-ay road accidents because of naiuban drivers kay naiuban lang is mga langhag or magpahad-had sa kalsada. So in this situation dyan, if you are a driver, the right thing you do is to be attentive. If imong kasugat or imong nakasunod is magka-conflict ba sa imong way or gahatag ba siyang signal light na kaning way iyang agian to avoid accidents lang and of course traffic, okay, magiging cause So I concur that the driver intent on crossing should do is to simply wait for the other vehicle to pass, for after all the other driver has the right of way. So failure to so wait is here negligence. So for culpa criminal, a pedestrian was injured because of the recklessness of a taxi driver. The pedestrian can bring an action of culpa appellatiana against the driver and the owner of the taxi company. But if the pedestrian wants, he may bring an action for culpa criminal, physical injuries through recklessness imprudence. In the same way, passenger may bring not only a suit for culpa contractual, but also a suit for a culpa criminal, physical injuries through recklessness reckless imprudence. So the injured pedestrian will file a criminal case against the driver, not against the owner. So, ang akong understanding lang about ano is that ma-involve lang bitaw ang owner if the driver is found guilty and if the driver is insolvent. Next is that, so there are procedure to be followed. The first is to present the judgment in the criminal case declaring the driver is guilty. So one of the definition provided in criminal negligence is that proof needed in a crime, proof of guilt beyond reasonable doubt. Moreover, accused is presumed innocent until the contrary is proved. So prosecution has the burden of proving the negligence of the accused. Second, to present proof of driver's insolvency by showing that the execution attempted by the sheriff could not be satisfied. So, in the absence of collusion between the driver and the prosecuting attorney, once the two exhibits are presented or proved, the judge should order the owner to pay. So the owner will not be allowed to present the defense of due diligence in the selection and supervision of his employee, for his liability is automatic and subsidiary. There is no necessity of previously reserving the case against the owner because the owner is not a defendant in the criminal case. After the criminal case is terminated, the convicted driver should pay. So if the driver be insolvent, the victim can now file a civil action against the owner to recover on the latter's subsidiary liability. Again, in culpa criminal, if the pedestrian wants, he can bring an action for culpa criminal against the driver, and the driver will be held liable if the judgment declaring that the driver is guilty. So if the driver is found guilty, the owner will be automatically and subsidiarily liable if the driver is insolvent, but the owner will not be allowed to present the defense of due negligence in the selection and supervision of his employee, and that is the rule in culpa criminal.
I'm Nicole Giuseppe Cagadas, one of the reporter of 1172.
A taxi driver of Baredo killed Garcia through reckless driving when the driver hit the carretela where Garcia was a passenger. The driver was found guilty in the criminal case, culpa criminal, but the civil action had been reserved. Later, the heirs of Garcia brought a civil action, culpa aquilania, directly against Berardo, the owner of the taxi cab company, Malati Taxi Cab Company. It was proved that Baredo was negligent for his driver had been employed by him even if he had previously been convicted for violation of the automobile law. Baredo contended, however, that the action should not have been brought against him at once, because according to the revised penal code, he should be liable only if the driver cannot pay, and that therefore the civil action should have been brought first against the driver, and then if the driver is found guilty and insolvent, this will not be proper time to take the action against him. Baredo is confused. It is true that in a civil obligation arising from a crime, the employer will be only subsidiarily liable in case the employee committed the crime in the discharge of the duties. But this case is not one of the civil liability arising from a crime, but one arising from a quasi-delict or culpa aquilina, and under the Civil Code provisions on torts,
An employer in a case like this is not merely subsidiarily, but primarily liable, and therefore a case can be brought directly against him. His defense can be due diligence in the selection and supervision of his employees, but here he was proven to be negligent. Hence, he can be made to pay immediately. Second case, Nagrania versus Mulwaney, INCL 8326, October 24, 1955. Facts. The driver of an employer was criminally found guilty of damage to property, and because he was insolvent, the employer was sued for his subsidiary civil liability. The victim asked for 1,300, but employer in his answer admitted liability for only 300 or 1,000 less. Issue: if both parties ask for judgment on the pleadings, can the employer be held liable for the whole 1,300, which has been adjudged as the driver's liability? Held. Yes, because of the automatic subsidiary liability, once the driver is found criminally guilty and insolvent, the offer of 300 pesos was an implied admitted a least amount of immaterial for, under the law, he is a complete subsidiary liability. Another case, number 3, Maria Luisa Martinez versus Manuel B. Barredo, et al. GR 49308. Fact: on April 11, 1940, a taxi cab owned by Fausto Berardo and driven by Rosendo Digman collided with a Chevrolet car driven by Maria Luisa Martinez. A criminal case was instituted against the taxi driver, who pleaded guilty and was made to pay a fine, and to identify Martinez relied solely on A. The judgment of conviction against Digman. Another one is the writ of execution issued against Digman and proof of his insolvency. Issue: would the evidence of Martinez be sufficient to hold Barredo civilly liable? Held. Yes. The judgment of conviction plus proof of insolvency is sufficient to hold the employer subsidiarily liable in the absence of conclusion between the driver and the victim. The stigma of a criminal conviction surpasses in effect mere civil liability. Common sense dictates that a finding of guilt in a criminal case in which proof beyond reasonable doubt is necessary should not be nullified in a subsequent civil action requiring only preponderance of evidence. Barredo cannot be said to have been deprived of his day in court because the liability really depends upon the driver's guilt and insolvency. The liability being automatic and subsidiary. It is high time that employers should have been employees defended very well, supplying them with counsel, for in defending his employees' interest in a criminal case. He, the employer, is automatically defending himself. It would have been different had that case been one of culpa qualania.
Good day, everyone. I am Eliza Leonoris, and welcome to today's discussion on the continuation of Article 1172 of the Civil Code of the Philippines. A reference is the book Obligations and Contracts by E. Baras. The article was already defined and tackled by the previous reporters. So now, let's discuss some cases where this article has been applied. We will start to analyze the case of People of the Philippines versus Jesus Verano. So let's start with the facts. The case revolves around the death of Dominador Peras, who was a passenger in a truck owned by the Mindanao Bus Company and driven by Jesus Verano. The truck figured in an accident that killed Peras, and the bus company paid his heirs $3,000 as compensation. However, Verano was later charged with homicide through reckless imprudence, and the lower court found him guilty. In addition to the present sentence, Verano was ordered to pay the heirs of Peras the sum of $5,000 with subsidiary imprisonment in case of insolvency. This is where the issue of waivers comes in. Mrs. Peras, in her own behalf and on behalf of her minor children with the deceased, waived further rights to recover damages from the bus company. But the issue in this case is whether the waiver in favor of the company embraces the civil liability of the driver, whether the right to recover upon the civil liability arising from the crime may be waived, and whether such a waiver may be made on behalf of the minor heirs by their mother. The court held the waiver in favor of the company means that the company will not be held liable for any civil damages caused by the driver, even in the case of the insolvency of the driver. This is because the revised penal code makes the company liable for the driver's actions. If the heirs were to recover from the driver as well, they would be receiving double indemnity, which is not allowed. Second, the rules of court state that civil liability, whether it arises from a crime or not, can be waived. This means that a person can choose not to hold another person liable for civil damages even if that person committed a crime. For the third one, the court cited Article 2032 of the Civil Code, which requires a court approval for any compromise or waiver that affects the property rights of minors. Since Mrs. Paras is the administrator of the children's property, she did not secure such approval, her waiver on their behalf is not valid. This means that the heirs of Paras can still recover $2,000, which is the part of the indemnity that has not been validly waived. The court reduced the indemnity in the criminal case to $2,000 instead of the original $5,000 to reflect the partial waiver. This shows how Article 1172, which requires the parties to fulfill their obligations in good faith, can influence the interpretation and application of other legal provisions. For the last part, Article 2177 states that responsibility for fault or negligence under Article 2176, culpa acaliana, is separate from the civil liability arising from negligence under the Penal Code ex delicto. This means that a person can be held liable for both civil damages under culpa acaliana and criminal damages under the Penal Code, but the plaintiff cannot recover twice for the same act or omission of the defendant. In other words, the plaintiff can only receive compensation for the damages once, even if the defendant is found liable under both culpa acaliana and ex delicto. Moving on to the next case, the case of Verata versus Ochoa, which was decided on January 31, 1978. In this case, the petitioners are the heirs of Arsenio Verata, who was killed after being hit by a passenger jeepney driven by Maximo Borrelia and registered in the name of Victoria Ochoa. The defendants filed a motion to dismiss the case on the ground, but there was another action pending between the same parties for the same cause, which was criminal case number 3160-3, a criminal case for homicide through reckless imprudence instituted against Borrelia. The issue is whether or not the petitioners, the heirs of the deceased Arsenio Virata, can prosecute an action for damages based on quasi-delict against Maximo Borrelia and Victoria Ochoa, the driver and owner, respectively, of the passenger jeepney that bombed Arsenio Virata. The Supreme Court held that the civil action for damages based on quasi-delict against Borrelia and Ochoa is not barred by the pendency of criminal case number 3162-B. To explain the basis of this decision, the court held that in negligence cases, the aggrieved parties may choose between an action under the revised penal code or a claim of quasi-delict under Article 2176 of the Civil Code of the Philippines. The prohibition under 2177 of the Civil Code of the Philippines is to recover twice for the same negligent act. However, the court clarified that Article 2177 does not bar a subsequent civil action for damages due to a quasi-delict or culpa appellana, even if the accused was acquitted of accusation of criminal negligence, provided that the offended party is not allowed to recover twice for the same negligent act. Thus, the court reversed the order of the lower court granting the motion to dismiss and remanded the case for further proceedings. In simple terms, if someone causes harm or damage to another person, they can be held liable for that action in two different ways, either through a criminal case or a civil case. If the harm or damage was caused by a criminal act, the person who caused it may be found guilty and ordered to pay compensation to the victim. However, if the harm or damage was caused by negligence or a quasi-delict, which is a non-criminal wrongful act, the person who caused it can still be sued in a civil case, even if they were acquitted of the criminal charges. This is because the two types of liability, criminal and civil, are separate and distinct, and an acquittal in a criminal case does not automatically absolve someone of civil liability. So, in the case of Maximo Borrelia, even though he was acquitted of the criminal charges against him, he can still be sued for damages in a civil case because the harm or damage was caused by his negligence or quasi-delict, which is a separate source of obligation from criminal liability. The court applied Article 117 in determining the liability of Borrelia and Ochoa for their negligent acts. The court held that the civil action for damages based on quasi-delict is separate and independent of criminal liability. Thus, Borrelia's acquittal for criminal negligence did not absolve him and Ochoa through civil liability for the death of Virata, as determined under Article 1172. In conclusion, the case of Virata versus Ochoa is a significant precedent in Philippine jurisprudence on negligence cases. It clarifies the distinction between criminal and civil liability in case of negligence and upholds the right of aggrieved parties to seek redress for damages under quasi-delict, even if there is a pending criminal case for the same cause. A driver's acquittal in a criminal case is not a bar to a civil case for damages. What is prohibited is a double recovery for the same negligent act. This means that if a driver is found not guilty in a criminal case, it doesn't mean they can be sued in a civil case for damages caused by their actions. However, the law doesn't allow someone to receive compensation twice for the same negligence, So if someone has already been compensated for damages through a criminal case, they can be compensated again in a civil case. Article 2179 of Civil Code states that when a plaintiff's own negligence was the immediate and proximate cause of his injury, he cannot recover damages because there is no culpa appellata on the part of the defendant. So if someone's own negligence directly caused their injury, they can sue for damages because the other person is not at fault. For example, if a pedestrian bumps into a car because they weren't paying attention, of course, they can sue the driver for any injuries they suffered. In fact, if the pedestrian caused damage to the car, the owner could sue the pedestrian to recover the cost of repairs. This is because the pedestrian's negligence was the sole cause of the accident and the driver had no fault in the matter. Article 2179 of Civil Code also states that if the plaintiff's negligence was only contributory, the immediate and proximate cause of the injury being the defendant's lack of due care, the plaintiff may recover damages, but the courts shall mitigate the damages to be rewarded. So if the plaintiff, the person who is suing, was also partly responsible for their own injury, but the main reason they were injured was because of the defendant, which is the person being sued, was careless, the plaintiff can still get some money for damages. However, the amount of money they get will be reduced because they are partly to blame for their own injury. This is according to Article 2179 of the Civil Code. Going forward to another case, the case of versus Metropolitan Water District, which involved the joining of a 14-year-old boy and one of the defendant's recreational swimming pools. The plaintiffs, who are the parents of the deceased, filed a complaint against the defendant, alleging that the latter was negligent in the provision of safety measures for its customers or visitors. The plaintiffs argued that the defendant should be held liable for the death of their son. The defendant, on the other hand, argued that the death of the plaintiff's son was caused by his own negligence or by an unavoidable accident. The defendant further claimed that it had exercised due diligence in the selection and supervision of its employees and that it had observed the diligence required by law under the circumstances. After trial, the lower court found that the plaintiff's actions were untenable and dismissed the complaint without making a pronouncement as to cause. However, the plaintiffs took the case directly on appeal to the Supreme Court because the amount involved exceeded the sum of $50,000. The central issue of this case is whether or not the resort was liable for the death of the plaintiff's son. In its decision, the Supreme Court held that the resort was not liable for the death of the plaintiff's son. The Supreme Court ruled that while the defendant was duty-bound to provide safety measures for its customers or visitors, it was not an absolute insurer of their safety. The court explained that the doctrine of last clean chance is a legal principle that applies in situations where both the plaintiff and defendant were negligent, but the defendant had the final opportunity to prevent the harm caused to the plaintiff. However, there are certain situations where the doctrine of last clean chance cannot apply. First, if the plaintiff's negligence was concurrent with the defendant's negligence, meaning both parties were at fault at the same time, then the doctrine of last clean chance cannot apply. Second, if the defendant was required to act instantly to avoid the injury, then the doctrine of last clean chance cannot apply. This is because there was no last clean chance for the defendant to act and prevent the harm. Thirdly, if the injury could not have been avoided despite the application application of all possible means to avoid it, and the defendant's previous negligence did not contribute to the injury, then deduction of last chance cannot apply. This means that even if the defendant had taken the final opportunity to prevent the harm, it would not have made a difference as the injury was unavoidable. In arriving at its decision, the Supreme Court applied Article 1172 of the Civil Code, which provides that responsibility arising from negligence in the performance of every kind of obligation is deniable. The court explained that the defendant had fulfilled its obligation to provide safety measures for its customers or visitors, and therefore it was not liable for the death of the plaintiff's son. In conclusion, the case of Paul versus Metropolitan Water District is an important case in Philippine tort law, as it establishes the principle that while establishments have a duty to provide safety measures for their customers or visitors, they are not absolute insurers of their safety. So, that will be all. Let's now proceed to the next reporter to further discuss the remaining cases.
Hi, and once again, I am Jovel Rose Fuegollanes, and I will be the one who will report to the case of Rakes and Atlantic Gulf and Pacific Co. And this case will relate it to the effects of the victim's contributionary negligence. Okay, now let's start. What is the facts? Unsay naa sa case? So, the case is all about Rakes, a Negro, was at work transporting iron rails from a barge in the harbor to the yard of the Atlantic Gulf and Pacific Company. At a certain point, the railroad track broke, upset the cart, and hit Rakes. So, si Rakes is na siyang gitrabahuan. Nagtrabaho siya, and at a certain point, ang railroad naguba o naigo si Rakes. His leg was afterwards amputated. So, giputol ang leg ni Rakes giputol tungod sa accident na hitabo. It was proved that the cause of the accident was a defect in the track, a depression therein. Previously, the depression had been noticed, but the repair upon it was done negligently. So it was proved na napatunayan na naay defect dito sa track mao nahitabo to na accident. And that depression have been noticed. Nahibalaan siya, pero ang pagka-repair, gipa-repair siya, pero ang pagka-repair is wala gitarong. And there is no question, therefore, of the company's negligence. So, makita dyan nato na nadyo negligence ang company. Kay even though wala gitarong o gipa-repair lagi nila, pero wala gitarong o repair. So, kung pwede, kung paraway may tabo na accident, pwede nila ipa-repair balik para ma-okay na dyan. Okay, so, naanay negligence ang company ana. But the companies countered by saying that Rakes himself was negligent in two aspects. So, niana ang company na dili naapod si Rakes, napoy negligent si Rakes. Ang una nila giingon is, although he noticed the depression, he still continued with his work. Mo na ang pinakauna na giingon. Even though nakita si Rakes na naay depression, napadayon ka pa siya og trabaho dito adapit. And ikaduha, instead of walking in front or behind the car, Rakes walked at the side. So, ang ingon sa company na, pwede naman na mula ka si Rakes sa atubangan or likod sa car. Nga dito aman just sa kilid. Diba? So, pero, the court dismissed the first ground by saying that Rakes did not know that the truck has been repaired negligently. So, gidismiss ang una ka ground sa korte, kag wala kabalo si Rakes na ang pag-repair day ato is wala gitarong. Pero, ang second ground na gikuan sa company is gi-admit sa court na nagpakita siya na naadyo negligent si Rakes. Okay. Now, what is the issue? Is the negligence of Rakes sufficient to bar him from a recovery of damages? So, ang issue is, tungod ba sa naay negligence na nahitabo kang Rakes or naay negligence si Rakes, sufficient na ba to, enough na ba to na dili siya maka-recover sa damages na naa sa iya, ha? na-earn niya or nakuha niya tungod ato na accident? But the answer is no. This negligence of Rakes did not bar him from recovery damages. Rakes did not contribute to the accident. He only contributed to the injury of damage upon himself. So no, pwede gapon siya maka-recover for damages because si Rick is wa siya nag-contribute sa accident, which is katong wala gitarong og repair ang truck. And only ni-contribute lang siya sa pag-injury sa iyang kaugalingon. Kay kung pwede, kung nikuan siya, kung nilakaw siya dito sa atubangan or likod sa car, o wala sa kilid, maybe there was, dili siya maunsa. Therefore, he can still recover. Nagapon siya ma-recover sa damages na iyang nakuha, but the damages should be reduced or mitigated because of his own contributionary negligence. Kay tungod na ay contributionary na hitabo, ma-reduce ang ma-recover niya na damages tungod sa iyang contribution, tungod sa iyang negligent pod mismo.
Good day, sir. I am Rosel Orongan, BS Management Accounting, and I am the last reporter of Article 1172.
Here are some doctrines of negligence. The Tumayo versus Giselle case. If an employer company fails to warn an ignorant employee to be careful about an unfamiliar machine, it should respond for damages in case of injury. It is a duty of a master to warn a minor or infant employees. This case is under culpa Aquiliana because the appellant is guilty of negligence where she fails to warn the young boy and causes him physical harm. When a person causes such damage, she must compensate the victim for them. Under the case of Wright versus Manila Electric Corporation, the mere fact that a man was drunk at the time of an accident does not mean he was negligent, provided he exercised due care. No negligence found in the part of Wright. As a general rule, it is immaterial whether a man is drunk or sober if no want of ordinary care or prudence can be imputed to him, and no greater degree of care is required to be exercised by an intoxicated man for his own protection than by a sober one. Under the case of Hashin and Corporation versus Roca and Corporation, storing a potatoes in a very tight and unventilated lurcher under a burning sun causing them to rot is a gross negligence. Therefore, the defendant was guilty of gross negligence with respect to the car of a potato on board the Lorca and is liable for the loss resulting therefrom. It is due entirely to the wrongful act and to the gross carelessness of the employees by evidence. Guzman versus Exxon Ben and Mayer and Company versus Philippine Motors Corporation, abandoning a towed vessel in Council just because the tool line broke and with full knowledge that it might get lost is negligence. Under Carlos Gukov versus Meralco, if the streetcar passenger is hurt because of an accident where there was no negligence at all, the streetcar company cannot be liable for culpa contractual for there were no negligence. Under Rodriguez versus Redline Transportation Company, a tire blowout does not constitute negligence unless the tire was already old and should not have been used at all. Indeed, this would be clear case of a fortuitous event. Tucker versus Milan cases. Negligence is a question depending upon the facts of each particular case. Indeed, it is a question of facts. Liability for the culpa Aquiliana of others. Under Article 2180 of Civil Code, the father and in case of his death or incapacity, the mother are responsible for the damages caused by their minor children who lived in their company, unless the parent can prove that he or she observes all the diligence of a good father of a family to prevent damages. Guardians are also liable for the damages caused by the minors or incapacitated persons who are under their authority and live in their company, unless said the guardian observes all the diligence of a good father of a family to prevent damages. And also, employers are liable for the damages caused by their employees and household helpers acting within the scope of their assigned task, even though the former are not engaged in any business or industry, unless the employers can prove that they observes all the diligence of a good father of a family to prevent damages. Under Article 218 of Civil Code, whoever pays for the damage caused by his defendants or employees may recover from the latter what he paid for or delivered in satisfaction of the claim. Under Article 2189 of Civil Code, provinces, cities, and municipalities shall be liable for the damages for the death of or injuries suffered by any person by reason of defective buildings and other public works under the control of their supervision. The case of Golden versus Lipkind. An innkeeper is under a duty to exercise ordinary care to keep hallways reasonably well lighted and free from obstructions and will, therefore, be liable in case a guest is injured when the hallway to his room is not lighted, and he trips over a mattress carelessly placed in the dark hole. It is the application of the diligence of a good father of a family, the duty to exercise reasonable diligence. The law imposed on hotels, apartments, and innkeepers the duty to keep their buildings, premises, and appliances in a condition reasonably safe for the use of their guests, or at least those parts of the building and premises in which guests are invited or reasonably expected to be used. The duty of maintaining safe premises cannot be delegated to another. There is a duty to exercise ordinary or reasonable care to keep the hallways and passageways reasonably well lighted and free of obstructions. It was the legal duty of the hotel to exercise ordinary care to have and keep the hotels safe. Therefore, an innkeeper is liable.
Thank you and God bless.